Ladies and gentlemen of the jury, the defendant has, beyond a reasonable doubt, committed arson. Eyewitness account and surveillance footage has clearly demonstrated the defendant in plain sight lighting a match and setting a home on fire. He has demonstrated the mens rea, or the deliberate intent to cause harm, by setting this building on fire through his actions. And it is clear for all of you to see right here, right now. As many of you may already know, arson, historically speaking, was a crime in common law against habitation, meaning that people have a right to feel safe and secure in their own homes. It's where they live, it's where they sleep, it's where they grow as people, and they have that right. And the defendant here today took away that right and that feeling of security. The purpose of arson being criminalized is to protect the home along with the occupants and their possessions from fire, which too often leads to death. And thank goodness it didn't today. Under the common law, arson required 5 elements, including intent or malice, the actual burning. The burning had to be of a dwelling or surrounding structure. The burned property had to belong to someone else other than the arsonist. Obviously, they couldn't burn their own home, or it wouldn't be arson. And lastly, the action had to occur at nighttime. However, under modern statutory law, which is what we follow now, arson now encompasses all acts that result in the intentional burning of any person's property at any time. So there's no longer any nighttime requirement. And so even though the defendant here today had committed arson in broad daylight, in clear sight for all to see, it still constitutes arson. And so in Colorado, which is where we are trying this case, arson can be in the first, second, or third degree, depending on the type of property involved, whose property it was, whether the fire was set intentionally, knowingly, or recklessly, and the value of the property involved. Now, given that there were people residing in and around the home at the time that this crime was committed, I believe, that the defendant should be punished most severely with arson in the first degree. It is an inhabited dwelling, a place where people deserve the right to feel secure, and he took this feeling away from them, and he damaged their property, which is a very serious crime and ought to be punished. Under Colorado Revised Statute 18-4-102, the punishment for first-degree arson ought to be 4 to 12 years in prison with 5 years of mandatory parole and a fine between $3,000 and $750,000, which of course will be at the judge's discretion. Now, I would argue that the fine should be significantly more than this $3,000, and should be upwards of $200,000, $300,000, maybe even $400,000, because there was no loss of life. But as we can see through the history of arson, and why arson is a crime, which is that we're harming other people by taking away their security, injuring their property, sometimes resulting in loss of life. This is a serious crime which ought to be punished, and it should be upheld for the defendant today. As we can see, he committed the crime and he ought to be punished. And with that, I rest my case. Thank you.